Do you want your legacy to be one of giving money to attorneys like myself? Then do nothing, don't have a plan, or have your plan centered on a last will and testament. Instead, though, if you want to leave behind a specialized, customized plan specific to you, your beneficiaries, and the legacy you want to leave behind, then you need a living trust. Hey guys, Jeff Cottle with Anderson Business Advisors, and today we're going to talk about 2 key pitfalls of a last will and testament and why they can actually be an enemy to your estate plan, and especially one that a lot of people don't talk about, but that is a huge problem. And then after that, we'll talk about how a living trust avoids both of these problems and helps you to secure the legacy that you want to leave behind. Let's dive right in. So, a last will and testament, at least according to literature and media, people tend to have this impression that it's big, long, detailed document that an attorney or a judge is going to read out saying, this goes to so-and-so or this other thing goes to so-and-so, or it all goes to the maid, or whatever else it might be, right? But the reality is that the last will and testament really doesn't work like that anymore. And there are 2 key reasons why. The first is that the last will and testament must go through probate. Probate is the court-approved and court-appointed process by which an individual's assets are passed along to their beneficiaries after they pass away. Probate is time-consuming and it's extremely expensive. And attorneys and judges ultimately end up deciding what happens to your estate. Very frequently, an estate is wasted away in probate court, paying for judges, paying for attorneys, paying for court fees, and very importantly, leading to our second reason, our second pitfall related to last will and testament. Many an estate, because of a will, ends up wasted away because the beneficiaries are fighting. So that first problem is the last will and testament has to go through probate. But the second and more important one, and one that a lot of people don't talk about, is that the last will and testament is very easy to challenge in court. What does this mean? It means that it opens the door for individuals to fight about what happens to your stuff. Unfortunately, this is not just fighting from the outside, somebody coming in and objecting, though this is certainly possible. Probate court is public. Among the many things wrong with it, probate court is public record. And so individuals from the outside can just jump in. But more frequently, it's actually your beneficiaries, your children, family members, friends, even charitable organizations that end up fighting amongst themselves about who gets the assets. Because probate is a court-appointed process open to the public, it's very easy for individuals, again, your beneficiaries, your heirs, to object, to fight over what happens to the stuff. I have seen many an estate wasted away in court because family members have fought amongst themselves. In fact, we had a client several years ago whose father left behind a legacy, truly a legacy, with an enormous farm up in a northern state, right? 600 plus acres. And this farm ended up having to go through probate. And our client described to us later that her brothers were able to file and object to the way that this farm was being handled. It's supposed to go mostly to her, but they objected, and they spent years. Her brothers, objected, and they spent years and years fighting in court. Devastatingly, what ultimately happened is that the parties settled. Our client and her brothers ended up settling out of court. Why? Because they had both racked up so much in attorney fees that they could not afford to keep the lawsuit going, and that the estate would not pay for it as a whole. So what they had to do is they had to sell off this property, their father's legacy, to pay their attorneys and part ways. It was devastating because our client's father's legacy became exactly what I talked about in the beginning. His legacy became one of giving money to attorneys. Why? Because his beneficiaries, his kids, ended up fighting amongst themselves, going through court, rather than having a proper plan in place. This is why it's so important for you to have an estate plan that is centered on a living trust. Living trusts do not have to go through probate. They can be settled out of court, which is perfect. This is exactly what we want. Even more importantly, though, is that in the living trust, you retain control. You can put together a specialized and specific plan for your beneficiaries that carries on your values, that carries on your belief system, and helps encourage your beneficiaries to do the same. And you can plan for specific beneficiaries who have, well, specific needs. I've helped many a client customize their trust specific to a child or a relative or even, again, a charitable organization's needs so that they can continue this specific purpose that our clients, or in this case that you, choose. So if you want to learn more about putting together an estate plan centered on a living trust that is not going to be subject to probate and that is not going to be wasted away on attorneys, then go ahead and click the link in the description. Schedule a consult, a free consult with one of our strategists, and we'd be happy to put together a plan for you. Hey, thanks guys for taking the time to watch. Hit that like and subscribe, like and subscribe buttons, and let me know in the comments if there's something else that you would like me to talk about. Look forward to seeing you soon. Take care.